No will, no liquidity, 2 Bay Area properties, including a multi-unit investment building, and court-confirmed probate sales required every step of the way. This isn't just another real estate story, it's a real case involving heir disputes, court filings, and a family administrator managing the entire process from out of state. In this video, I'll walk you through how we sold both properties legally, efficiently, and for top dollar while navigating probate court, limited authority, and a family conflict. If you're a family administrator, professional fiduciary, or an attorney representing either and facing a probate sale with any complexity, this is exactly what you need to know. If we haven't met, hi, I'm Andrew DeVries. I help professional and family fiduciaries sell probate and trust real estate in the San Francisco Bay Area with less stress, less liability, and for more money. I've closed over 900 of these transactions, and with this channel, I'm here to help you avoid costly mistakes. So let's dive in. These clients began with a referral to me from a top estate planning attorney in the San Francisco Bay Area. The client was an out-of-state administrator whose brother had unexpectedly passed away without a will. The family administrator had never managed a real estate transaction before, which is very common, much less one involving both a home and a multi-unit investment property, all under scrutiny of the probate court. Because there was no will and the estate had complex family dynamics, including objecting family members, the court granted the administrator with limited authority. That meant every step of the estate and the real estate had to go through the court, which is far more demanding in public than a traditional estate administration or traditional real property sale. To make matters more difficult, there were heirs from the brother's first wife, adult stepchildren represented by their own attorneys who filed objections to the administrator's role. Add to that the fact that the administrator had no local support, no vendor network to support what needed to be done in the Bay Area, no local real estate market insight, and no experience with tenant-occupied properties. And it was clear they needed a local, trusted probate real estate expert to help navigate not just the sale, but the legal and logistical minefields surrounding it. And that's when I was brought in. During our first meeting, I sat down with the attorney and administrator to map out a clear, legally sound strategy. First, we had to determine whether it made more sense to sell both properties and/or keep and distribute the income-generating multi-unit. So I conducted a full rent versus sale analysis, weighing the potential long-term income, expenses, and possible personal liabilities of the property against the administrative complexities and the legal and market risks for the heirs. Once it was clear that selling both properties was the most prudent option for the estate, I developed a comprehensive real estate sales strategy, one that included property preparation, target buyer segments, valuation analysis, and timeline planning. But this wasn't just about getting the administrator and the attorney aligned. Because of the family conflict and active legal objections, we presented the full plans to the attorneys for their contesting heirs. This transparency helped to de-escalate tension and ensured everyone understood the rationale behind every decision. In addition, that strategy document became more than just a roadmap. It became a legal record, a clear explanation of what was done, why it was done, and how it protected the estate and upheld the fiduciary duty of the administrator. With that consensus in place, we moved forward with the correct probate listing agreements, one for the single-family home and one for the multi-unit investment property, each reviewed and approved by the estate attorney. With the plan in place, we turned our focus to preparing both properties for sale. The home and multi-unit building both needed work, clean out, minor repairs, and basic updates to make them market ready. But with no local support and no liquidity in the estate, the administrator didn't know where to begin. So I developed a detailed set of suggestions for how to best prepare both for a top dollar sale, pulling from my 20 plus years of direct probate sale experience, and I brought in licensed, bonded, and insured vendors I trust. People who've worked with me on probate and trust sales for years to deliver bids for the suggested work within days. The multi-unit property came with additional challenges. Because it was tenant-occupied, we had to comply with local rent control laws and tenants' rights, including proper notice, respectful communication, and coordination for inspections and buyer showings. To protect the administrator and preserve goodwill, I acted as a direct liaison with the tenants and property management. I handled the written notifications, managed access logistics, and ensured everything was done by the book. Since the estate had no available funds and the referral came from a top Bay Area estate planning attorney I had worked with in the past, I provided an interest-free fix-up loan reimbursed through escrow to cover all necessary prep. This allowed us to move quickly and avoid unnecessary delays. Throughout the preparation process, I managed everything from scheduling to budgeting and sent regular updates to the administrator and attorney. This expert project management saved the estate a tremendous amount of time and money and avoided costly overages, which are famous in renovation projects. This project oversight and transparency wasn't just helpful, it was critical, especially with potential scrutiny from contesting heirs or the court before, during, and after the sale. With preparation underway, we tackled the next key piece, legal disclosure and title review. In probate, administrators have fewer disclosure obligations than a traditional seller, but they're still legally required to provide certain documents, and the consequences of getting that wrong can be serious. To simplify the process and minimize liability, I worked with the administrator to complete our firm's specialized probate sale disclosure packet, which had been refined over the past 20 plus years and 900 plus sales to meet legal standards and reduce exposure for both the estate and the fiduciary. On the title side, we partnered with a trusted title company to review the chain of title early for both the home and the multi-unit buildings. We checked for liens, ownership inconsistencies, and anything that might stall escrow. We also submitted the court-issued letters of administration and probate filings to the title company in advance to ensure they'd underwrite the administrator for title insurance. By proactively managing disclosure and title, we avoided last-minute legal issues such as getting a seller into contract before they have title authority to sell, kept the sales compliant with buyers' title insurance underwriting, and built a clear record showing the administrator's good faith and due diligence. That kind of preparation isn't just smart, it's what protects estates and earns the confidence of buyers and attorneys alike. Once both properties were ready, we launched targeted, high-visibility marketing campaigns, one tailored for the single-family home and another for the multi-unit property. For the home, we highlighted the improvements we made, the desirable Bay Area locations, and created a strong emotional appeal for families and buyers looking for value. For the investment property, we took a more analytical approach. I prepared a full offering memorandum with financials, tenant details, local rent control information, and cap rate projections. This positioned the building for serious investor attention. Our outreach included digital advertising, local and national MLS exposure, buyer network alerts, and placement on platforms reaching international investors. Both campaigns paid off. We received multiple offers, including several over asking on both properties. But because the administrator had limited authority, we couldn't just accept offers and move forward. We needed probate court confirmation. I worked with the estate attorney to file the petitions and secure the hearing date. Then, based on my decades of court-confirmed sales experience, I remarketed the property for 2 weeks before the court hearing. This ensured any overbidders had a clear understanding of the process, terms, and requirements, so there were no surprises in court. It's that level of guidance that turns legal complexity into a smooth, professional transaction for the court, the heirs, and the administrator. For more information on court-confirmed sales, please go to my YouTube channel for a great video on exactly how court-confirmed sales work. After the court confirmed both sales, I took the lead on managing 2 parallel escrows, ensuring every moving part stayed on track. That meant working closely with both sets of buyers, their lenders, and our title partners to coordinate appraisals, ensure financing was finalized, and handle any post-confirmation disclosures or conditions. Because of our prep work, there were no surprises. Both escrows moved forward smoothly. All signatures were collected, timelines were honored, and I kept the administrator and attorney updated every step of the way, despite them being out of state. When the dust settled, we closed both transactions at the highest possible price, on time, and with full legal and fiduciary documentation in place. The proceeds were wired directly to the estate's account, and every action, every repair, every decision, every negotiation was clearly documented to protect the administrator from challenges by heirs or court questions. What started as a deeply complex and contested probate situation ended as a textbook example of what's possible when legal precision meets strategic real estate execution. And that's exactly what I provide. Navigating a probate sale with no will, limited court authority, multiple properties, and contested heirs isn't just difficult, it's overwhelming. But with the right strategy, legal alignment, and real estate execution, it can be done successfully and with full protection for the administrator and the estate. This case is proof. If you're managing a complex probate situation or advising someone who is, you don't have to figure it out alone. I've helped hundreds of families, fiduciaries, and attorneys do this right the first time. Call me today or visit probateagent.com. I'm here to help you turn a challenging probate case into a well-documented success.